Okay, welcome to the deep dive. Get ready to plunge into a truly fascinating and, yes, pretty complex world, how you protect designs here in the UK.
Mhm.
If you're someone who creates, makes, or just deals with manufactured goods, this is absolutely crucial knowledge. It's about understanding how to shield your own creative ideas.
Or, just as important, making sure you're not accidentally infringing on someone else's rights.
Exactly.
That's exactly right. When we talk about protecting design, so the law isn't typically trying to protect the underlying article itself.
Yep.
Not the chair, not the phone, not the car body panel.
Right.
It's focused specifically on the appearance of that article. How does it look?
Mm.
Think of it as taking a functional product and adding something visual, some specific design feature that enhances its look, gives it
Rad.
character.
Okay.
That visual feature is what the law aims to protect. This is a big difference from patents, which protect the underlying invention or how something works.
And it seems there's a bit of a legal judgment built into this, isn't there? Designs that have a strong visual impact on the person using them or seeing them are often seen as, well, more deserving of protection than something purely functional.
Yeah, that tends to be the case. They often get longer protection terms and face fewer easy defenses when challenged. But let's be honest, it's not a seamless, perfectly logical system.
No, definitely not.
Far from it. Legal scholars like Bentley et al. Have candidly described design law as multi-layered, complex, and lacking in logic, and, well, anyone who's navigated it would likely agree.
So a designer in the UK has several potential legal routes they could take to protect their creation.
That's right, multiple options.
And for this deep dive, our mission is to guide you through some of those key layers and help make sense of it. We're going to concentrate specifically on copyright and the UK unregistered design right.
UDR.
We'll cover registered design law and the newer supplementary unregistered design right, but primarily to provide context and show you the whole landscape.
Yeah, just as background, really.
By the time we're done, you should feel much clearer on when copyright can protect designs, when those slightly annoying rules step in to exclude it, what you need to prove to get unregistered design right protection, and what its main features and limitations are.
And it's worth saying, this deep dive is based on valuable materials made available by the University of London, and it's intended for educational purposes only.
Absolutely. Crucial point.
We also want to extend a big thank you to Sinorbit Academy Sri Lanka for bringing this session to you.
Yes, thanks to Sinorbit Academy.
And to any students out there preparing for your exams, we know this material can be dense, so we'll try to highlight key cases and concepts, maybe repeat them a few times to help them stick.
Definitely. We'll flag the really important bits.
So good luck with your studies.
Okay, let's set the stage then. Understand how we ended up with this multi-layered system in the UK. It hasn't always been this way, has it? There's
No.
been a kind of pendulum swing in policy over the years.
That's right. Historically, the UK's approach has fluctuated quite a bit. At times, it pushed designers towards requiring registration under specific design acts to get protection.
Right.
At other times, it allowed them a choice between registration under something like the old Registered Designs Act, the RDA, or, interestingly, relying on existing copyright law.
So before the big overhaul, the Copyright Designs and Patents Act of 1988, the CDPA, before that, designers had options.
They did.
If they started with a drawing, which, many designs do, they could potentially use the copyright in that 2D drawing to stop people making 3D copies of the article.
Exactly. That was a common strategy before 1988. But that landscape was dramatically reshaped by a really pivotal case in 1986, British Leyland v. Armstrong patents. Remember that one?
The car exhaust pipes case?
That's the one. Spare parts for cars. The House of Lords, the highest court at the time, was pretty critical of using copyright law in engineering drawings to prevent the manufacture of spare parts needed for repair.
So that case was a major trigger for reform. It sort of forced Parliament's hand.
Absolutely. The consequence was the introduction of the CDPA in 1988, which included very specific provisions aimed at significantly cutting back the availability of copyright protection for industrial designs.
Oh.
Parliament wanted to ensure that copyright, which lasts for a very long time, wasn't being used to grant lengthy monopolies over, well, commonplace functional articles.
But the CDPA didn't just take away copyright, it also introduced something new, didn't it?
It did. Alongside curtailing copyright, the CDPA created a brand new automatic copyright type right specifically for designs, the unregistered design right, or UDR.
UDR, right.
This was intended to provide some protection for designs that previously might have relied on copyright, but on a shorter term. kind of a replacement, but different.
So some copyright protection did remain for designs after the CDPA.
Yes, crucially, some residual copyright protection remained for articles that could be considered artistic works in their own right, like sculptures or works of artistic craftsmanship.
Ah,
The CDPA didn't abolish copyright for all designs, just limited its application for many. It's also really important to understand from the outset that this UK unregistered design right, the one introduced in 1988, is quite unique to the UK.
how so?
Its specific rules and criteria are different from UK registered designs, and the later supplementary unregistered design right we'll touch on. It's its own thing.
Speaking of registered designs, that law evolved too, right? The RDA.
It did. The UK's Registered Designs Act was revised in 2001. This was done primarily to bring UK registered design law into line with the EU Designs Directive.
Right, harmonization across Europe.
Precisely. Directive 9871/EC harmonized the criteria for registered design protection across member states, moving towards concepts like novelty and individual character. We'll look at those briefly.
And the EU didn't stop there. They created a whole new EU-wide system too.
Yes, in 2002, with the regulation on the community design. This established the EU Registered Design, which granted a single registration covering all EU member states, administered by the EU Intellectual Property Office, UIPO. And critically, it also created an informal automatic right called the EU Unregistered Design Right. Until the end of 2020, both these EU rights covered the UK.
And then Brexit happened.
Indeed. When the Brexit transition period ended at the close of 2020, the legal landscape shifted again. Existing EU-registered designs that covered the UK were automatically converted into comparable UK national registered designs.
Okay, so they continued in the UK.
Yes, and the protection provided by the EU unregistered design right that was active in the UK was preserved by granting holders a new, purely domestic UK right.
Which brings us to yet another new right. This is getting complicated.
It is a bit, yes, the supplementary unregistered design right. This is a UK-only right that lasts for a maximum of 3 years from the date the design is first made available to the public.
Only 3 years.
Maximum 3 years, yes. And its criteria for protection are actually the same as those for registered designs based on novelty and individual character.
Ah, so not like the original UK UDR.
Exactly. The original UK UDR uses a different test, not commonplace, which we'll get into. The supplementary one mirrors the registered system criteria.
Okay, so if I'm a designer in the UK right now trying to figure out how to protect my latest creation, I potentially have quite a few routes. It really is multi-layered.
Absolutely. As the source material lists, your potential choices could include, first, a UK registered design, which, if granted and renewed, can last for up to 25 years.
Okay, the long-term option.
Second, the UK unregistered design right, the UDR we started talking about. This has a theoretical maximum life of 15 years.
15.
Theoretical max, yes.
Yeah.
But realistically, because of certain rules about licenses, its truly valuable exclusive life is often limited to the first 5 years. And remember, this one has its own unique rules for what counts as a protectable design, the not commonplace test.
Right, the unique UK one.
Third, the supplementary unregistered design, right? The newer, shorter one. Maximum 3 years from publication, same criteria as registered designs.
Okay.
And finally, in some specific and limited circumstances, UK copyright protection might still be available.
So what's the headline on the trade-offs here? Registered versus unregistered. That seems key.
That's a really key distinction. The big advantage of a registered design is that it gives you a true monopoly right.
A monopoly.
Yes. If someone makes or uses an article that falls within the scope of your registered design, you don't have to prove they copied you. They simply made it, and that's infringement, assuming your registration is valid.
That sounds powerful. What's the downside?
Well, it takes time and money to go through the registration process, and your registration can always be challenged later if someone thinks it shouldn't have been granted, maybe it wasn't actually new, for example. There's that risk of invalidity.
Whereas the unregistered rights, UDR and copyright, are automatic.
Correct. They are instant and free from the moment the design is created and meets the criteria or recorded made into an article for UDR. But the absolutely crucial trade-off, and this is vital for exams, is that to successfully sue someone for infringement, you must prove they copied your design.
Must prove copying.
Yes. If they came up with the same or a very similar design entirely independently without reference to yours, you have no claim under UDR or copyright. That need to prove copying is fundamental.
Got it. Okay, so registered equals monopoly, but it costs money and carries risk. Unregistered is free and automatic, but you absolutely have to prove copying. That's a really important takeaway.
Now, while our main focus today is on unregistered rights and copyright, it's helpful to have a basic understanding of the registered system just as background context, as the source material suggests.
Okay, makes sense. So briefly, how does someone actually register a design in the UK? What's the process?
You file an application with the UK Intellectual Property Office, the UKPO. They conduct what's called a formalities examination.
Formalities. Just checking boxes.
Pretty much. They're essentially checking that your application is complete, that you've paid the fee, and crucially, that you've provided clear representations like drawings or photos of the design you want to protect. You need to show it clearly, maybe from different angles, and say what product it applies to.
But they don't check if it's actually new or different enough.
No, that's the key thing about the UK system. They do not conduct a substantive examination to see if your design actually meets the legal criteria like novelty or individual character. That's left for others, like competitors, to challenge after the registration is granted, perhaps in court or back at the IPO.
So they check the paperwork, and if it looks okay, they basically grant the registration. Seems a bit easy.
It's relatively straightforward compared to patents, yes. You need to define exactly what design you're claiming protection for in the representations. The process typically takes maybe a few months, up to 12 months. Once registered, the initial term is 5 years.
And you can renew it?
Yes, you can renew it 4 times, each for another 5 years, giving that maximum protection period of 25 years we mentioned.
Okay, 25 years is a good long time. How does the RDA, the Registered Designs Act, actually define what a design is for registration purposes?
Section 1(2) of the RDA is the definition. It says, design means the appearance of the whole or a part of a product, resulting from the features of, in particular, the lines, contours, colors, shape, texture, or materials of the product or its ornamentation.
So it's really all about the visual look and feel. Appearance.
Precisely, the appearance. And product, under Section 1(3), is defined very broadly. Any industrial or handicraft item other than a computer program.
So pretty much any physical object.
Almost. It includes things like packaging, the getup of goods, graphic symbols, typographic typefaces, and importantly, even parts that are intended to be assembled into a complex product.
And complex product has a specific meaning too.
Yes. Section 1(3), again, it defines it as a product composed of at least 2 replaceable component parts permitting disassembly and reassembly. Think of a car, maybe. A key change under the current law compared to the older versions is that you can now protect just a part of a product.
Like just the wing mirror of a car.
Potentially, yes. And even internal features, provided they are visible during normal use for these complex products.
Okay. What are the key legal hurdles for a design to actually qualify for registration? You mentioned novelty and individual character.
That's right. Those are the 2 main positive criteria, similar to the system across the EU, updated back in 2001, novelty and individual character.
Novelty sounds like patents. Does it mean completely new?
Yes, very similar concept.
Yeah.
Under Section 1(b)(5), a design is considered new if no identical design, or one differing only in insignificant immaterial details, has been made available to the public before you apply to register it, or claim priority from an earlier application.
And made available to the public is pretty broad, like anywhere in the world.
It is. It means published, exhibited, used in trade, or otherwise disclosed anywhere in the world. So something shown at a trade fair in Japan could destroy the novelty of your UK application if it wasn't kept confidential.
Wow. So secrecy for filing is key.
Absolutely critical. There are a few exceptions, though. Disclosure doesn't count if it wasn't reasonably knowable in the relevant business sector in the normal course of things, or if it was disclosed in breach of confidence, which is why confidentiality agreements, NDAs, are so important when showing designs early.
Right.
And there's also a 12-month grace period. If you, the designer, disclosed your own design within the 12 months before you filed your application, that disclosure doesn't destroy novelty. But relying on grace periods can be risky, especially internationally. Best practice: keep it secret until you file.
Good advice. Okay, so that's novelty. What about the second criterion, individual character?
This is under Section 1(b)(3). It means the overall impression your design produces on the informed user must be different from the overall impression produced by any existing design that has been made available to the public before your filing date.
The informed user, you said just a regular person buying something.
It's a bit more specific than just any customer. It's someone who is reasonably knowledgeable about designs in that particular sector. They're not necessarily an expert designer or engineer, but they are observant, they know the market, they pay attention to details and the overall look. Think of maybe a keen DIY enthusiast looking at power tools, or someone really into fashion looking at handbags.
Okay, so someone familiar with the field.
Exactly. And Section 1B4 also says that when you're assessing individual character, you should consider the degree of freedom the designer had in creating it. Were they heavily constrained by functional needs, for example? If they had very little freedom, even small differences might be enough to create a different overall impression.
Makes sense.
And for components of complex products, remember, their individual character is only assessed if those components are visible when the final product is being used normally.
So novelty is about objective difference from prior designs, while individual character is about the overall visual impression being distinct through the eyes of someone who knows the market a bit.
That's the core idea, yes. Novelty and individual character, key terms for registered designs.
Are there things that are automatically excluded from registered design protection, even if they seem new and have individual character?
Yes, there are categories that simply cannot be registered under the RDA, listed in the source material. These include, first, features of shape dictated solely by the product's technical function. If the shape has to be that way to work, you can't register it as a design.
Function is for patents, right?
Generally, yes. There's also an exclusion for must-fit features, the bits that allow one product to connect to another, like the specific shape of a plug or connector. Though, interestingly, this doesn't prevent protection for modular systems, like Lego bricks, where the connection shape is actually part of the design's appeal.
Okay. What else is excluded?
Designs that are contrary to public policy or accepted principles of morality. Also, certain specially protected emblems, like national flags or royal crests.
Mm-hmm.
And finally, designs that are too similar to an earlier registered design, whether a UK one or an EU one converted after Brexit, or designs that would infringe an earlier trademark or copyright.
Okay, so function, fitting, public policy, emblems, and conflicts with earlier rights can all block registration. What about ownership and the rights you get? Who owns a registered design and what can they stop others from doing?
The ownership rules are now generally aligned with those for unregistered design right, which we'll look at in more detail later. But the basic rule is the designer is the first owner, unless the design was created during their employment, in which case the employer owns it. And a key change from the Intellectual Property Act 2014, remember this one, is that like EU registered designs, the designer is now the owner of commissioned designs.
So if I hire someone to design something for me, the designer owns the registered design, not me, the commissioner, unless we agree otherwise.
Exactly. That reversed the old UK rule where the commissioner used to own it automatically. So now, the designer owns it unless there's an agreement transferring ownership. The owner of a registered design gets an exclusive right to use the design under Section 7.1 of the RDA.
And use is broad.
Very broad. It includes making, offering, putting on the market, importing, exporting, using, or stocking any product incorporating the design or to which the design is applied.
And the protection isn't limited just to the specific type of article shown in the registration, like if I register a design for a chair.
That's an important point. The protection extends to any article to which the design is applied, as long as applying it to that other article doesn't create a different overall impression on that informed user we talked about.
So if I registered a design for a distinctive pattern on a teacup, the protection could potentially extend to someone putting that exact same pattern on, say, a plate, if it still creates the same overall impression.
Potentially, yes. The scope isn't limited just to teacups.
That makes sense. Are there standard defenses against infringement? Like if I use it privately?
Yes. Section 7A of the RDA provides defenses that are similar to those for patents. These include things like using the design privately and for non-commercial purposes, using it for experimental purposes, or for teaching.
Okay.
There's also a defense for using components specifically to repair a complex product, but only to restore its original appearance. The repair clause.
And how can a registered design be challenged? Can someone try to get it canceled after it's granted?
Yes, it can be declared invalid. Section 11ZA of the RDA lists the grounds for invalidity. These pretty much mirror the requirements for registration and the exclusions. So if it turns out the design wasn't actually new or lacked individual character or was dictated by technical function or was contrary to public policy or belonged to someone else,
Right.
or if it conflicts with an earlier registered design or infringes an earlier trademark or copyright. Who can challenge depends on the ground. For instance, only the owner of the earlier trademark can challenge based on conflict with their trademark.
Okay, so that gives us the essential background on registered designs. It's a strong, potentially long-lasting monopoly right, but it costs money and takes time to get. requires novelty and individual character judged by an informed user, has specific exclusions like function and must fit, and importantly, it can be challenged and potentially invalidated after grant. Now, let's really focus on copyright and how it interacts with designs, which is one of our main areas today. Copyright protection is automatic, right? You don't register it.
That's right. Copyright protection arises automatically in the UK under the CDPA from the moment a qualifying work is created and fixed in some material form. Section 4 of the CDPA lists the categories of works that can get copyright protection, and this is where designs might fit in.
Which categories under Section 4 are most relevant to designs?
For designs, we are primarily looking at two categories from Section 4.1. First, Section 4.1 covers a graphic work, photograph, sculpture, or collage, irrespective of artistic quality.
Irrespective of artistic quality.
Yes, that phrase is very significant. It means the court doesn't judge whether something is good art or not when deciding if it's a graphic work, photo, sculpture, or collage. And the second relevant category is Section 4.1c, which covers a work of artistic craftsmanship.
Okay, let's break down Section 4.1a first. Graphic works, sculpture, etc. How low is the bar for a graphic work?
The source material highlights that the threshold is incredibly low. Section 4.2 defines graphic work very broadly. It includes drawings, diagrams, maps, charts, plans. A classic case illustrating this is British Northrop v. Textine Blackburn. In that case, simple engineering drawings for basic machine parts were held to be plainly artistic works under the definition.
Plainly artistic works, even for functional machine parts.
Yes. The judge, Margery J., famously suggested that anything which goes beyond a single line on a piece of paper is a drawing, which really shows just how basic the threshold for a drawing as a graphic work can be.
Wow, so even a technical drawing for something purely functional, like a screw or a gear, can potentially be a graphic work protected by copyright.
Yes, that's the historical position based on the definition. And remember, Section 4.1 also includes 3D items like sculptures. This means that every day, manufactured articles could potentially qualify for copyright if they are considered a sculpture.
Even a mass-produced item.
Potentially. Cases like Waymo Manufacturing Co. v. Lincoln, that was a New Zealand case on similar law regarding toy frisbees, and the UK case, High-Tech Auto Parts v. Towergate, 2 Ltd, have explored this possibility.
But you mentioned a modern qualification, something about EU law.
Yes, influenced by European Union law, which still applies as retained law in the UK. The work must now also be the result of the author's own intellectual creation to be considered original enough for copyright. It needs that spark of creativity expressing the author's personality. This is a standard applied across different categories of works, not just artistic ones.
Okay, so it needs to be original in the sense of the author's own intellectual creation. What about the other category, Section 4.1c, work of artistic craftsmanship? This sounds like it requires more than just a basic drawing or shape.
It absolutely does.
Yeah.
This is a trickier composite concept. The work must be both artistic, meaning it has some genuine artistic or aesthetic quality, and it must be a work of craftsmanship, meaning it's made by a skilled person exercising their craft. Both elements must be present.
So not just skillfully made, but also artistic in some way. How do courts decide that?
It's notoriously difficult. You really need to delve into the case law to get a feel for it. Key cases include Hansher v. Restwile, about prototype furniture, and Vermont and Powell v. Bondcrest Ltd. Quilts. There's no single clear test.
And the source specifically points to the first instance judgment by Man J. in Lucasfilm Ltd. v. Ainsworth. That's the famous case about the Star Wars Stormtrooper helmet design, right?
It is. Man J's analysis in Lucasfilm, which was later affirmed by the Supreme Court, is cited as containing an excellent explanation of both sculpture and work of artistic craftsmanship in the context of manufactured articles like the helmet. He examined whether the helmet could qualify under either category. Reading that judgment is really helpful for understanding these concepts.
Now, this concept of artistic craftsmanship, especially maybe how the UK courts interpreted the artistic part, seems to have potentially run into issues with EU law recently, hasn't it?
It has. There's been a significant development here due to the European Court of Justice case C68317 Cofemel v. G-Star Raw CV.
Cofemel, what did that say?
The CJEU ruled that commercially produced designs, like clothing in that case, can be protected by copyright if they meet the fundamental EU definition of a work, which essentially means it's identifiable and original in the sense of being the author's own intellectual creation. And crucially, the CJEU said that national courts cannot impose additional aesthetic tests or qualifications beyond that basic concept of a work.
Ah, so if the UK's traditional approach to artistic craftsmanship involved judges making a separate assessment of whether something had sufficient artistic quality or whether the creator intended it to be artistic requirements potentially going beyond just originality, then that approach might be in doubt.
Precisely. The Cofamel ruling is a principle of retained EU law in the UK post-Brexit, so it continues to influence how we interpret copyright originality. This creates a potential tension, particularly for the work of artistic craftsmanship category. Does the artistic requirement in S.41c impose a condition beyond the Cofamel standard of originality? It's an area of ongoing debate.
And there's a recent case, Water Rower UK Ltd v. Liking Ltd, that touches on exactly this, doesn't it? The rowing machine case.
Yes, Water Row from 2022 is very relevant here. It involved a claim for copyright in the design of a distinctive water rowing machine. The claimant argued it was both a work of artistic craftsmanship under the traditional UK approach and that it met the EU-derived originality standard from Cofamel.
What did the judge say about the water rower design? Could it be copyrighted?
Well, it was an interim decision, but the judge found that the claimant had a real prospect of proving it was a work of artistic craftsmanship at a full trial. He suggested it was possible to show real artistic or aesthetic quality and sufficient craftsmanship and artistry, but this was left for the trial judge to decide definitively.
Okay, so the traditional route wasn't dismissed.
No. But perhaps more significantly, the judge also found the design met the Cofamel requirement of being an original object and an expression of the designer's own intellectual creation. He stated there was a real prospect of success on that ground, too.
So even a functional item like a rowing machine could potentially get copyright protection under this EU-derived standard if there was enough creative choice involved in its design.
Exactly. The water rower case is important because the judge specifically noted that the technical constraints on the designer weren't so restrictive that the underlying idea and its expression were inseparable. The designer had creative freedom, for example, in the choice and aesthetic use of wood, and this was seen as creative expression sufficient for originality.
Okay, so copyright can protect the initial drawings or models related to designs, as graphic works or sculptures needing originality. Or it could potentially protect the finished articles themselves if they qualify as sculptures or works of artistic craftsmanship. Again, needing originality with a question mark over additional artistic hurdles for craftsmanship post-Cofamel. But how does copyright in a 2D drawing give you rights over a 3D article made from it? That seems like a jump.
That's covered by a key provision, Section 17.3 of the CDPA. It's crucial for design protection via copyright. It states that reproducing a 2D artistic work like a drawing in a material form includes converting it into a 3D object, and vice versa.
So taking a drawing of a chair and actually building the chair based on that drawing is legally considered a reproduction of the 2D drawing in 3D.
Precisely. The old case LB Plastics v. Swish Products, which was decided under the previous Copyright Act but had an identical provision, confirmed this principle. It held that 2D engineering drawings for plastic drawers were infringed by the 3D drawers made according to those drawings.
The appeal of copyright for designs, then, is that it's instant protection from creation, no registration needed, automatic.
Right, that's the big plus. But remember, the fundamental requirement for infringement, you must prove copying.
Copy again.
Always for copyright and UDR. This involves showing two things. First, derivation, that the defendant had access to your work and actually used it, and second, that they took a substantial part of it.
And the test for what counts as a substantial part comes from that big House of Lords case, Designers Guild Ltd v. Russell Williams Textiles, Ltd, Lord Millett's speech in particular.
Yes, Designers Guild is the leading authority on substantial part in copyright. Lord Millett explained that you compare the original work and the alleged copy, identify the features that have been taken, and then assess whether, qualitatively, those features constitute a substantial part of the original work. It's about the importance of what was taken, not just the sheer quantity or percentage.
Quality over quantity.
Exactly. So copyright can subsist in design drawings or potentially in the articles themselves if they meet the criteria for artistic works, giving automatic protection against substantial copying. But, and this is a big but, this is where Parliament introduced those restrictions we mentioned earlier because relying on the very long term of copyright for everyday industrial items seemed undesirable. That's exactly it. The tension between using long-term copyright for industrial designs led Parliament to introduce specific limitations, primarily found now in Section 51 of the CDPA. There used to be another important limitation in Section 52, but that has since been repealed, which is a significant change in itself.
Okay, let's focus on Section 51 first, but can you briefly recap the historical attempts to limit copyright for designs before the CDPA, just to see the evolution?
Yes, sure. Under the Copyright Act 1956, there were a couple of interesting but ultimately flawed approaches. Section 9(8) introduced something called the non-expert defense.
Non-expert defense.
Yeah, it basically said there was no infringement if an ordinary person, a non-expert, wouldn't recognize the 3D article as being a copy of the 2D drawing. That defense wasn't carried over into the CDPA in 1988. Then there was Section 10, which initially excluded designs that were eligible for registration under the Registered Designs Act from copyright protection altogether.
So if you could register it, you lost copyright.
Initially, yes. And that led to the bizarre situation highlighted in the case Dorling v. Honor Marine.
What was bizarre about it?
Because Section 10 only excluded registrable designs, it meant that non-registrable designs, often the more functional ones that couldn't meet the aesthetic requirements for registration back then, actually got the full long term of copyright protection, while the more potentially artistic registrable ones were excluded. It was completely upside down.
That does seem odd. So the Design Copyright Act 1968 tried to fix this.
Yes, it amended Section 10. The fix was to grant copyright protection to registrable designs, but limit that protection to a shorter term of 15 years, matching the then term of registered designs. This gave designers a choice: register for a potential 15 years under the RDA, or rely on copyright for a guaranteed 15 years if their design was registrable.
But the British Leyland case we mentioned earlier, the spare parts one, interpreted this amended Section 10 in a way that kept the problem alive for functional parts.
Exactly. The courts interpreted the amended Section 10 as still only applying to designs that could be registered. Designs that couldn't be registered, like many functional spare parts, still fell outside of Section 10 and therefore, arguably, got the full, long term of ordinary copyright based on their engineering drawings. This kept the door open for copyright claims against manufacturers of spare parts and other functional items.
Which is why the House of Lords in British Leyland felt compelled to create that controversial non-derogation from grant or spare parts defense.
Yes. Out of what they saw as public policy, necessity ensuring people could repair things they'd bought, they effectively devised a defense to stop copyright owners of drawings for everyday items from using that copyright to prevent third parties from making essential spare parts needed for repair. It was a pragmatic solution by the court, but it was criticized for creating legal uncertainty.
Okay, so that history brings us to the CDPA's own solution in Sections 51 and 52. How does Section 51 work today? Because that's the main restriction now, right?
It is. Section 51(1), CDPA is still very much in force, and it's crucial to understand. It states, and the wording is key, it is not an infringement of any copyright in a design document or model recording a design for anything other than an artistic work to make an article to the design.
Okay, let's break down that carefully worded phrase. Design document or model recording a design. What does that cover?
Section 51(3) helps with definitions here. A design document is defined very broadly as any record of a design, which includes drawings, written descriptions, photographs, data stored electronically, samples, pretty much any way of capturing the design.
And design for anything other than an artistic work.
Okay, two parts here. First, what's a design in this context? Section 51(3) defines design as the design of any aspect of the shape or configuration, whether internal or external, of the whole or part of an article other than surface decoration.
Wait, any aspect of... Didn't you say that phrase was removed from the definition of design for UDR?
I did, and that's a subtle but absolutely critical difference between Section 51 and UDR. The phrase any aspect of remains in the Section 51(3) definition of design, but it was removed from the Section 213(2) definition for UDR by the Intellectual Property Act 2014.
So design might be interpreted more broadly under Section 51 than under UDR now.
Potentially, yes. It could cover more abstract features under Section 51 because any aspect of is still there. Also note that surface decoration is explicitly excluded from this definition of design for the purpose of Section 51.
Okay, and the second part, for anything other than an artistic work. That links back to Section 4.
Exactly. This is the absolute crux of Section 51. The whole section hinges on whether the design recorded in the document or model is for something that is not an artistic work.
Okay. The source material highlights 3 key observations about how Section 51 operates. Let's go through those.
Yes. First observation. Section 51(1) does not destroy the copyright in the design document itself. Copyright still subsists in the drawing, the blueprint, the CAD file. If someone just photocopies your drawing or emails the CAD file, that is still copyright infringement of the document itself. Section 51 only says that the specific act of making a 3D article to that design is not infringement of the copyright in the document, provided the conditions in Section 51 are met, i.e. it's a design for something other than an artistic work.
Got it. So copyright in the drawing still exists for things like photocopying it, but you often can't use it to stop someone making the 3D object if Section 51 applies. It pushes you towards UDR for 3D copying.
Right. Second observation. The key word in Section 51 is for. The rule applies to a design document or model recording a design for an article. If the 2D work isn't really a design document for making an article, think of, say, a painting that happens to depict a teapot, rather than a technical drawing for manufacturing a teapot, then Section 51 doesn't apply. In that case, making a 3D article based on the painting could still infringe the painting's copyright.
Okay, so if the drawing is just a depiction of something, not really instructions or a plan to make it, Section 51 is irrelevant.
Precisely. Third observation, and this is perhaps the most critical one to grasp, you have to look at whether the article which is made from the design document is itself an artistic work in its own right.
The finished product.
Yes. This takes us right back to our earlier discussion of Section 401A and C. Is the resulting 3D article a sculpture or a work of artistic craftsmanship?
So the analysis is, step 1, is there copyright in the design document? Usually yes, as a graphic work. Step 2, is that document a design for an article? Usually yes for industrial designs. Step 3, is the article that would be made from that document an artistic work itself?
Exactly. And the answer to step 3 determines if Section 51(1) applies. If the article is an artistic work, for example, it qualifies as a sculpture, then Section 51(1) does not apply. In that case, full copyright protection potentially applies to the article itself, and making copies would infringe that copyright, subject to proving copying, etc.
And if the article is not an artistic work?
If the article made is not an artistic work, think of a mass-produced functional item like a standard chair, a car part, most clothing, then Section 51(1) does apply. In that situation, you cannot use the copyright in the design document to prevent someone making that non-artistic article. You're generally left to rely on unregistered design right, UDR, for protection against the 3D copying.
So let's take an example. If your design document is a technical drawing for a plain functional chair, you probably can't use copyright in the drawing to stop someone making the chair because the chair itself isn't an artistic work. Section 51 applies. You look to UDR.
Right.
But if your design document is, say, a sketch for a unique artistic chair that is genuinely considered a sculpture, then Section 51 might not apply, and you could potentially rely on the copyright in the sculpture itself to stop copies.
That's the key distinction Section 51 forces you to make. It hinges entirely on the artistic status of the end product.
Are there cases that illustrate this?
Yes, several. Joe Y. Joe Ltd v. Madeline Retail Ltd is a good example where Section 51 prevented a copyright claim for copied clothing designs because clothing wasn't seen as an artistic work. Flashing Badge Co. Ltd v. Groves involved badges. The court suggested that while the basic shape of the badge might be a design for a non-artistic work, caught by S.51, the artwork printed on the surface of the badge could be a separate artistic work, a drawing perhaps, whose copyright was not affected by Section 51 when it was copied onto other badges.
Ah, separating the underlying shape from the surface decoration.
Exactly. And BBC Worldwide Ltd v. Pally Screen Printing Ltd involved printing images of the Teletubbies onto T-shirts. This raised questions about whether applying a 2D artistic work onto an article was the same as making an article to a design document for the purposes of Section 51.
This really reinforces how important that distinction between simple graphic works, like the design document, and actual artistic works, like sculptures or works of artistic craftsmanship judged by Lucasfilm, etc., is for navigating Section 51.
Absolutely fundamental. Understanding Section 4 artistic works is key to understanding the Section 51 exception.
Now, you mentioned another provision that used to curtail copyright. Section 52 has been repealed. What did Section 52 do, and what's the effect of its repeal?
Section 52 was designed to address the anomaly of artistic works getting very long copyright protection, even when they were mass-produced industrially. It basically said that if an artistic work, like a sculpture or work of artistic craftsmanship, was applied industrially, meaning more than 50 articles were made, or was applied to machine-made goods, then its copyright protection was limited to 25 years from first marketing.
Ah, so it tried to align the term for industrially applied artistic works with the term for registered designs.
Exactly. That was the policy aim. To prevent, say, a designer chair that qualified as a work of artistic craftsmanship getting life plus 70 years protection when a registered design for a similar chair only got 25 years.
But you said Section 52 has now been repealed.
Yes, it has been repealed. This happened relatively recently.
So what's the effect of that repeal? It sounds significant.
It is very significant. It means that artistic works, even if they are applied industrially and mass-produced, now enjoy the full term of copyright protection.
Which is
Typically the life of the author plus 70 years.
wow. So that designer chair that qualifies as a work of artistic craftsmanship now gets life plus 70 years copyright, even if thousands are made.
That's the current position, yes. The repeal of Section 52 dramatically extended the potential duration of copyright for industrially exploited artistic designs.
That's a huge change. So in summary for copyright curtailments, Section 51 is the main one still active. It stops you using copyright in the design document to prevent 3D copying if the resulting article isn't an artistic work itself. And while artistic designs applied industrially used to have their copyright term cut short to 25 years by the old Section 52, that section is gone, so they now get the full, much longer copyright term.
Given that Section 51 dramatically restricted the use of copyright protection for many common industrial designs, Parliament needed to create an alternative form of protection, and that's where the unregistered design right, UDR, comes in. It was introduced by the CDPA back in 1988, specifically to fill that gap.
So it's intended as a sort of replacement, but maybe shorter term, protection for designs that fall outside the scope of full copyright because of Section 51.
That's the basic idea, yes. The policy rationale, which was set out in the government's white paper before the act, was essentially to provide manufacturers who invest time, skill, and money in creating original designs with some form of protection against copying. It's about giving them an incentive and a limited period of lead time to benefit from their design efforts before others can freely copy.
The source describes Part 3 of the CDPA, which governs UDR, as complex. Is it hard to get your head around?
It can be intricate. There are lots of specific rules and definitions.
Yeah.
But the absolutely central provision, the real heart of UDR, is the definition of what qualifies as a protectable design in Section 213 of the CDPA. If you can get to grips with Section 213, you're a long way towards understanding UDR. It's the foundation.
Okay, let's break down Section 213 then. How does it start?
It starts simply enough in Section 213.1. Design right is a property right which subsists in an original design. Well, sounds straightforward. But then the key question is, what does design mean for UDR?
Section 213, presumably.
Exactly. Section 213.2 provides the crucial definition. It defines design for UDR purposes as the design of the shape or configuration, internal or external, of the whole or part of an article.
Okay, let's unpack that. Shape or configuration, whole or part article. That sounds quite broad. Shape or configuration, internal or external.
It was intended to be broad, yes. The case, Ocular Sciences Ltd v. Aspect Vision Care Ltd, provides a helpful example used in the source. Think of a teapot. The UDR could potentially exist in the shape of the whole teapot, or just the shape of the lid, or the spout, or the handle, or even the internal shape of the lid where it fits the pot. All potentially parts of the article.
Does the design need any artistic quality or even need to be visible to qualify for UDR? Like registered designs need eye appeal.
No, that's a key difference. UDR does not require any artistic merit or eye appeal. The design can be completely functional, purely technical. It can even be invisible during normal use, or too small to see without aid, like the specific shape of a contact lens, which was the subject of the Ocular Sciences case.
So function doesn't exclude it here.
Not inherently, no, although there are specific exclusions we'll come to. It can also protect very simple shapes, as long as they meet the other criteria, like the simple geometric shape of a plastic clip in Sales v. Stromberg.
And it protects the design itself, not just its application to one specific article.
Exactly. The UDR protects the design, the shape, or configuration. That design might then be applied to different articles. The case Electronic Techniques, Anglia, Ltd v. Critchley Components Ltd, gives the example of a specific handle design. The UDR is in the handle design itself, which would then be used on a spoon or a fork or something else entirely.
What's the difference the law draws between shape and configuration? They sound similar.
They are closely related. Shape generally refers to the external form or outline of an article or part. Configuration, as explained in the case Mackey Designs Inc. v. Behringer Specialized Studio Equipment, relates more to the relative arrangement of the various parts of an article to each other, how things are put together.
An article, does it have to be a 3D object?
While article generally suggests something three-dimensional, courts have found that it can include essentially flat items as well. The source mentions Lambretta Clothing Co., Ltd v. Teddy Smith, UK Ltd., which involved the design of clothing, treated as potentially including 2D aspects like cut. Other examples where UDR has been recognized in articles include mobile phone cases, Parker v. Tidball, contact lenses, ocular sciences, and individual kitchen units, Mark Wilkinson Furniture. Interestingly, in the Mark Wilkinson case, while an individual unit was an article, a whole fitted kitchen was held not to be a single article.
Right. Now, you mentioned earlier that the Intellectual Property Act 2014 changed the Section 213(2) definition by removing the words any aspect of. Can you explain what that means in practice again? It seems important.
It is important, yes. This was a key change aimed at narrowing the scope of UDR slightly, to limit protection for very minor or trivial features and reduce uncertainty. Before 2014, the definition referred to the design of any aspect of the shape or configuration. You could arguably claim design right in almost any feature you could point to. The deletion of any aspect of was intended, according to the government's explanatory notes at the time, to clarify that protection applies to the shape or configuration of parts of articles, not just abstract aspects, and to limit protection for trivial features.
So, how have courts interpreted this change? What's the difference between a protectable part and an unprotectable aspect now?
The courts have had to grapple with this. In DKH Retail Ltd. VH Young Operations Ltd., the judge, HHJ Hakon, suggested that parts that are protectable post-2014 must have a concrete quality. They need to be identifiable sections or components, whereas aspects that are no longer protectable are more like claims to disembodied designs or concepts.
Concrete versus disembodied? Can you make that a bit clearer?
Yes. Mrs. Justice Carr, as she then was in Neptune, Europe, Ltd v. DeVol Kitchens Ltd., provided a very helpful explanation, building on Hakon's point. She described aspects, the pre-2014 language, as disembodied features which are merely recognizable or discernible, whereas parts, the post-2014 language required for protection, are concrete parts, which could be identified as such.
Okay.
She used the teapot example from ocular sciences again to illustrate. She suggested that under the new law, without any aspect of, claiming design right just in the combination of the very tip of the spout and the very top surface of the lid, considered together but separate from the main spout and lid parts, would likely be claiming an aspect, a disembodied concept, and thus probably not protectable. You need to claim the design of a concrete part.
That concrete versus disembodied distinction is helpful. Does this 2014 change apply retrospectively to designs created before the Act came into force?
Neptune Europe Ltd. also addressed this. The judge held that the amendment is generally not retrospective for acts of infringement that happened before the Act came into force, 1st October 2014. However, for any infringement happening after that date, the legal test for whether a design qualifies under Section 213(2) uses the new, narrower definition without any aspect of, even if the design itself was created before 2014.
So the current law applies to current infringement, regardless of when the design was made.
That's the effect, yes. And the Schnuggle v. Munchkin case from 2019 concerning a baby bath design reinforced this interpretation. The judge confirmed that post-IPA 2014, a part of an article under Section 213(2) must be an actual but not abstract part, which can be identified as such and which is not a trivial feature. Whether a feature is trivial is a question of fact based on the overall design of the article.
Okay, so the definition in Section 213(2) requires a design related to a concrete, non-trivial shape or configuration of an article or a part of it, not just a general idea or abstract aspect. Now, Section 213(1) also says the design must be original. Does original mean the same as in copyright, just not copied?
No, this is another crucial distinction for UDR. Original here has a specific two-part meaning defined in Section 213(4). It means the design must be original in the copyright sense, as not copied from somewhere else. And it must be not commonplace in the design field in question at the time of its creation.
Not commonplace. That sounds like a higher bar than just not copied.
It is. This not commonplace requirement is unique to UK UDR. The definitive interpretation comes from Lord Justice Mummery in the Court of Appeal case, Farmer Build Ltd v. Carrier Bulk Handling Materials Ltd. He said at a clear two-stage inquiry. Step 1. Was the design original in the copyright sense, not copied? The claimant, the person asserting the right, has to prove it wasn't copied. Step 2. Even if it wasn't copied, is the design nonetheless commonplace? The defendant, the alleged infringer, has the burden of proving that it is commonplace.
And how strictly is commonplace interpreted? Does it mean totally generic?
Yes, it's generally interpreted quite narrowly by the courts so as not to deprive the designer of protection, as the source notes. Mr. Justice Laddie in Ocular Sciences gave a good description of commonplace. He said it means things like trite, trivial, common or garden, hackneyed, or of the type which would excite no peculiar attention in those in the relevant art.
So it's not just, have I seen something vaguely like this before? It really has to be boringly standard, nothing special.
Exactly. Just because features are familiar doesn't automatically make them commonplace. And there's a specific methodology, again from Farmer Build, pages 482-83 in the law report worth knowing for exams, for assessing commonplace status.
What's the methodology?
First, you identify the relevant design field. You shouldn't define this too narrowly. Then, you objectively compare the claimant's design with similar articles that were already known and made available to the public by unconnected persons in that design field before the claimant's design was created. Expert evidence is often used here. You look at the similarities and differences between the claimant's design and the prior art. Crucially, the defendant's alleged infringing design is completely irrelevant at this stage of assessing subsistence. You only look at the state of the art before the claimant created their design.
So you survey the design landscape at the time the design was created and see if the claimant's design really stands out as different, or if it's just standard fare for that field.
That's the essence of it. Cases applying this test include Scholes Windows Ltd v. Magnet Ltd, where designs for Victorian-style windows were found to be commonplace in the broad field of window design. In contrast, in a Fulton Company Ltd v. Grant Barnett and Company Ltd, a particular design for an umbrella handle and case was found not to be commonplace.
Does commonplace only look at very recent designs that were around just before, or can old designs make something commonplace?
Dyson Ltd v. Qualtex confirmed there's no time limit on the prior art for the commonplace test. Old established designs absolutely count towards making a new design commonplace if it's too similar to them.
Can a design made up of features that are individually commonplace still be protected by UDR if the combination is new?
Yes, absolutely. This is a really important point. UDR can subsist in a combination of features which, taken individually, might well be commonplace, but when put together in that specific way, create an overall design that is not commonplace. Ultraframe UK Ltd v. Clayton, a case involving a conservatory roof framing system, is a key authority for this principle. The combination can be original even if the parts aren't.
And the IPA 2014 made a change to the geographical scope of the commonplace test.
Yes. Before 2014, the commonplace assessment was primarily based on the design field in the UK. Now it's assessed based on the design field in all qualifying countries, which includes the UK and various other territories, mainly linked to the EUEA or specific reciprocal agreements. So the prior art base is potentially wider now.
Okay, so to qualify for UDR, it must be a design of a concrete, non-trivial shape or configuration of an article or part. And it must be original, which means two things. It wasn't copied, and it's not commonplace in the relevant global design field when compared objectively to prior designs made by others.
Now, even if a design meets those positive criteria in Section 213.2 for shape configuration part in Section 213.4 for originality not commonplace, there's another hurdle. Certain types of features are specifically excluded from UDR protection by Section 213.3.
Ah, the negative criteria.
Exactly. And the correct approach, according to the courts, Ultraframe UK Ltd v. Clayton decided, is to first identify and mentally subtract any features that fall under these exclusions in S.213.3. Then, you apply the not commonplace test only to the features that remain after you've removed the excluded ones.
Okay, makes sense. What's the first exclusion in Section 213.3?
Section 213.3 excludes features of shape or configuration which correspond to a method or principle of construction.
Method or principle of construction. What does that mean? How something is made?
Essentially, yes. It's about features that are dictated by how the article has to be put together or manufactured. But this exclusion is meant to be given a narrow construction, according to the case Landor and Hawa International Ltd v. Azure Designs Ltd. It generally only applies if the specific shape is required, because that particular method or principle of construction cannot be achieved in any other way.
So if there are multiple ways to construct something using different shapes, and the designer chooses one method and its associated shape, that shape might not be excluded because they had a choice. They weren't forced into that shape by the construction method itself.
That's the general idea. If the shape is just one option among several for achieving that construction, it's less likely to be excluded. Examples of things that have been found to be excluded under this heading include shapes dictated purely by the choice of material, like the profile of aluminum wardrobe doors in Christopher Tasker's Design Right references, or the necessary location of a part like a fuel tank on a specific model of lawnmower, Roll-On Ltd v. Turfmech Machinery Ltd, or the shape of mesh used in a fishing bait bag if that specific mesh design was the only way to make it function properly, Bailey v. Haynes.
Okay.
It can also cover features dictated by how the article is assembled, like the pattern of internal stitching needed to hold a phone case together, as seen in Parker v. Tidball, though decorative stitching might be different.
Has the removal of any aspect of from Section 213.13 affected how often this method of construction exclusion applies?
It might mean this exclusion applies less frequently now. If a claim was previously based on a very general aspect related to construction, that aspect might not even qualify as a protectable part anymore under the post-2014 definition. But the exclusion is definitely not redundant. The source mentions Action Storage Sys Ltd v. GeForceEurope.com, Ltd, where the court considered it still relevant, potentially excluding specific mesh designs like in the Bailey v. Haynes example, if that shape truly was dictated by the construction method.
Okay, so method or principle of construction is the first exclusion. What are the next two, which are often referred to together as must fit and must match?
These are both found in Section 213(3)(b), and their underlying policy rationale is mainly about ensuring competition in the market for spare parts and accessories. They aim to allow manufacturers to make compatible articles that connect to or match existing products.
But you said earlier they are not as broad as the old British Leyland spare parts defense that the courts created.
That's right. Parliament considered reinstating a broad spare parts defense when enacting the CDPA, but specifically decided not to. The courts have confirmed that these exclusions in S.2133R are narrower and weren't intended to remove all protection for spare parts, ultra-frame and Dyson cases. So it's really important to look carefully at the precise wording of the statute here. Must fit and must match are just convenient shorthand labels.
Okay, let's look at the wording for must fit first. That's Section 213(3)(bi).
Right. This subsection excludes features of shape or configuration which enable the article to be connected to or placed in, around, or against another article so that either article may perform its function.
So it's all about the connection point, the interface.
Exactly. The focus here is on the interface between two articles or things, the features that allow them to physically connect or fit together so they can work.
And another article can include the human body, like a contact lens fitting an eye.
Yes. Some cases have held the human body can be considered an article for this purpose. So examples of excluded must-fit features include the internal curvature of a contact lens that needs to fit the shape of the eyeball, ocular sciences, or perhaps the external shape of a phone case that needs to precisely fit the phone itself, or even fit the user's hand. Parker v. Tidball mentioned the hand fit.
Is it just external connections or internal ones too?
There's been some debate in the cases about whether it applies only to external connections or also to components fitting together internally within a larger product. The source suggests the better view, following the Critchley components case, is that it can apply to internal components fitting together. But arguably its most common and clearest application is for the interface between a consumable or spare part and the main product it connects to, ultra-frame Dyson.
Okay, so that's must-fit features enabling connection for function. Now for must-match, Section 213(3), what's the wording there?
This subsection excludes features of shape or configuration, which are dependent upon the appearance of another article, of which the article is intended by the designer to form an integral part.
Dependent upon appearance. Integral part. This sounds like it's aimed at things like car body panels matching the rest of the car.
Precisely. This exclusion has been examined more recently in cases like Dyson Ltd v. Qualtex, which looked back at the old law under the Registered Designs Act, specifically the case Ford Motor Company Ltd's design applications.
What did the Ford case say about car parts being dependent and integral?
In the Ford case, the court drew a distinction. It found that things like car body panels, doors, and the bonnet were excluded because their shape was clearly dependent on the overall appearance of the car design, and they were intended to form an integral part of that car. However, other parts like steering wheels, wing mirrors, wheels, and seats were not considered dependent on the overall car's appearance in the same way you could have different styles, so they were capable of protection. Dyson v. Qualtex essentially adopted this line of thinking for UDR.
So the key word here is dependent. The shape has to be driven by the look of the thing it attaches to.
Yes, dependent is crucial. The test, as stated in the Dyson judgment paragraph 64, is basically asking, would the overall appearance of the other article, or against the whole vacuum cleaner or the car, be radically different if the replacement part, for example, a specific trim piece or a door panel, were not the particular shape it is? If removing or changing that part radically alters the look of the whole, then its shape is likely dependent on the whole and excluded by must match.
What about that case on body-enhancing jeans, Freddie Spia v. Hugs Clothing Ltd? Did must match apply there? The defendant argued the jeans' shape depended on the human body.
That was an interesting argument in Freddie v. Hugs. The defendant claimed the special shaping and seams of the jeans fell under the must-match exclusion because their design was dependent on the appearance of the human form. The judge, Mr. Justice Stone, left open the tricky question of whether the human body is an article for this exclusion, but found the exclusion didn't apply anyway. Why? Because the jeans were not intended by the designer to form an integral part of the human body in the sense meant by the act. They were simply clothing intended to be worn on the body.
That makes sense. Jeans aren't really integrated like a car door is. Okay, the final exclusion listed in Section 213.3 is subsection C, surface decoration. How can surface decoration be considered part of the shape or configuration only to be excluded?
That's a good question. It seems counterintuitive, but the case Mark Wilkinson Furniture v. Woodcraft Designs clarified this. Surface decoration isn't just flat patterns like paint or transfers. It can also include features that are technically three-dimensional, but primarily serve a decorative purpose, like shallow carved grooves, beading, or maybe ribbing on a surface.
So if you carve a floral pattern into a wooden box, it changes the shape slightly, but it might still be considered surface decoration and excluded from UDR.
Yes, potentially. It becomes a question of degree. If the 3D decoration is very minor or clearly just applied to the surface, it's likely excluded under S.21333. However, if the 3D feature is so significant that it becomes integral to the overall shape of the item itself, think maybe deep structural carving or sculpting, then it might cross the line from being mere surface decoration and become part of the protectable shape itself.
So fine lines sometimes.
Definitely. It's also worth remembering that while surface decoration is excluded from UDR, which protects shape configuration, that decoration itself can often be protected separately by copyright as an artistic work, like a drawing or engraving under Section 4, provided it meets the copyright criteria. We saw that with the flashing badge case.
Right. Are there examples of surface decoration being excluded from UDR?
The source mentions the Lambretta clothing case again, where the choice of colors for a garment was argued about. The court seemed to suggest color choice wasn't shape and might be excluded as surface decoration, though the source notes this was based on unusual facts. Generally, simple patterns, textures applied purely for looks, or 2D decoration would fall under this exclusion.
Okay, so the exclusions from UDR under Section 213.3 are method or principle of construction, the must-fit interface features, the must-match dependent features of integral parts, and surface decoration. You apply these first, subtract those features, and then you assess if the remaining shape configuration features are not commonplace under Section 213.4.
Now let's talk briefly about when and how UDR actually comes into existence or subsists. There are a couple of formal requirements and some crucial differences from copyright here, especially regarding qualification.
Okay. It has to be recorded in material form, right? Like copyright needs to be fixed.
Similar concept, yes, but slightly different wording. Section 213.6 says UDR does not subsist unless and until the design has been recorded in a design document or an article has been made to the design.
Or an article has been made. So you don't actually need a drawing or a CAD file. Just making the first physical product is enough for the UDR to potentially subsist in its design.
Correct. Subsistence can arise just by manufacturing the first article based on the design, assuming the design itself qualifies. That's a key difference from copyright, which generally requires the work itself, like the drawing, to be recorded in some material form before protection arises. For UDR, making the object can be the trigger.
Interesting. And here's where we see a major difference from copyright. The qualification rules. Who or what qualifies a design for UDR protection?
Absolutely.
Yeah.
This is arguably the biggest practical difference between UDR and copyright subsistence. UDR is much, much more restrictive in who can own it or benefit from it compared to copyright. Copyright is largely based on international conventions, like the Berne Convention, offering broad protection to creators from member countries. UDR is not.
So UBR qualification is more parochial, tied to specific countries.
Very much so. Qualification for UDR depends on specific connections to qualifying countries. The rules are laid out in sections 218, 219, and 220 of the CDPA, and you have to follow a very specific priority order when applying them.
What's the order?
Step 1. Look at section 218. If the design was not created in the course of employment, qualification depends on the designer. The designer must be a qualifying person at the time the design was created.
Okay, designer first. What if they were employed?
Step 2. Look at section 219. If the design was created in the course of employment, then qualification depends on the employer. The employer must be a qualifying person.
Designer, then employer. What if neither is a qualifying person? Is that the end of it?
Not necessarily. Step 3. Look at section 220. Only if qualification doesn't arise through the designer or the employer can the design still qualify if the first marketing of articles made to the design occurred in a qualifying country, and the person who did that first marketing was a qualifying person or acting with their license.
So designer, employer, or first marketer in a qualifying country. You have to check them in that specific order.
Precisely. The order matters.
And what makes someone a qualifying person? You said it's very narrow?
It is indeed very narrow compared to copyright. Under Section 217, a qualifying person is essentially an individual who is a citizen or subject of or habitually resident in the UK or an EEA state or another country listed in a specific order in council, OIC, or a body corporate, a company, which is incorporated under the law of or has a substantial business activity in the UK, an EEA state, or an OIC state.
An order in council state. Why are so few countries covered by those OICs?
Because, as I said, UDR is not governed by major international conventions like Berne or TRIPS. Countries are only included in these specific OICs if the UK government decides they offer equivalent, reciprocal protection for UK nationals' designs in their own country. Historically, this has meant mainly some Commonwealth countries or former colonies.
So major design economies like the USA, Japan, China, they're generally not qualifying countries for UDR purposes.
Generally not, unless the designer or company has a relevant connection via the UK or EEA. The consequence is that non-European companies and designers often find they cannot claim UK UDR protection. The Mackie Designs Inc. v. Behringer case is a well-known example where a U.S. company was denied UDR protection due to lack of qualification.
So qualification for UDR depends heavily on the designer, employer, or first marketer having a specific, quite limited connection to the UK, the EEA, or one of a small number of reciprocal countries listed in an OIC. That's a critical limitation to remember.
It is absolutely crucial. Now, the ownership rules for UDR, found in sections 214 and 215, largely mirror these qualification rules.
So who owns it follows who qualifies it.
Pretty much. The general rule is in section 214. The designer is the first owner of the design right.
Okay, designer owns it by default. What are the exceptions?
Exception 1 is in section 215.2. If the design was created by an employee in the course of their employment, then the employer is the first owner, same as copyright.
Right.
Exception 2 is in section 215.4. If the design only qualifies for protection because of the first marketing rule under section 220,
Right.
then the person who first marketed it, or the person who commissioned that first marketing, is the first owner.
So ownership follows qualification.
Yeah.
Designer, unless employed, employer owns. Unless only qualified by first marketing, first marketer owns.
That's the basic structure. But there was that important change under the Intellectual Property Act 2014 regarding commissioned designs. Remember this one?
Ah, yes, you mentioned it for registered designs too. How did it affect UDR ownership?
Before the 2014 Act, if you commissioned someone to create a design for you, the commissioner was automatically the first owner of the UDR. The IPA 2014, Section 2, changed this to align UDR with EU-registered designs. Now, for commissioned designs created after the Act came into force, the designer is the first owner in all cases, unless there is a contract explicitly assigning the rights to the commissioner.
So the default switched for commissions from commissioner owns to designer owns.
Exactly. A very significant change for freelance designers and those who commission them. You need a contract to transfer ownership now.
Identifying the correct owner is obviously vital because only the owner can take legal action for infringement.
Exactly right. Standing to sue depends on ownership.
What about the duration of UDR protection? We know it's shorter than copyright, but how does it work exactly?
Yes, definitely shorter. The rules are in Section 216. UDR technically lasts for 15 years from the end of the calendar year in which the design was first recorded, in a design document or by making an article. But if articles made to the design are made available for sale or hire anywhere in the world within the first 5 years, it lasts for 10 years from the end of the calendar year in which that first marketing occurred.
Okay, so it's either 15 years from creation recording or 10 years from first marketing, whichever period ends earlier.
Correct. Since most commercially successful designs are marketed within 5 years of creation, the effective maximum duration under Section 216 for most products is 10 years from first marketing.
10 years. Still much less than copyright. But you mentioned another catch. Something about the last 5 years?
Yes, this is crucial for understanding the practical value of UDR. Section 237 introduces licenses of right. During the last 5 years of the design right term, whether it's the 15-year or 10-year term, any person is entitled to demand a license from the UDR owner to do anything which would otherwise infringe the UDR.
A compulsory license, so the owner has to grant it.
Yes. They must grant a license. If the parties can't agree on the terms, like the royalty rate, the intellectual property office or the court can settle the terms, which must be reasonable.
What's the practical effect of that?
The practical consequence is that the period of true exclusivity, where the owner can completely stop others from using the design, is effectively limited to the first 5 years of the UDR term, i.e., the 10-year term minus the last 5 years subject to licenses of right. After that, competitors can get a license and compete, albeit paying a royalty.
So maximum theoretical 15 years, but usually 10 years from marketing, and commercially valuable exclusivity really only lasts for the first 5 years before these compulsory licenses kick in. That really shortens its effective lifespan.
It does significantly differentiate it from copyright and registered designs in terms of exclusivity duration. Finally, just to note, UDR can be treated like other intellectual property in terms of transactions, sections 222, 225. The owner can assign the right, grant exclusive or non-exclusive licenses, and even sign RODs that haven't come into existence yet, future UDR.
All right, let's move on to infringement of unregistered design right. How does an owner of UDR stop others from using their design? What are the exclusive rights?
The exclusive rights granted to a UDR owner are actually quite a bit narrower than the bundle of rights you get with copyright. There's essentially only one act defined as primary infringement, and that's in Section 226.
Only one. What is it?
Section 226.1 says the owner has the exclusive right to reproduce the design for commercial purposes. And subsection 1A clarifies this means reproducing it by making articles to that design, or R, by making a design document for the purpose of enabling such articles to be made.
So directly making infringing products for sale or making the blueprint or tools specifically to allow those infringing products to be made is primary infringement.
Yes, provided it's done for commercial purposes. And, crucially, just like copyright, reproduction involves copying. Section 2226 says infringement occurs if the design is reproduced exactly or substantially. And subsection 3 makes it clear that reproduction can be direct or indirect.
And copying means not independent creation.
Exactly. Mirroring copyright, independent creation is a full defense to UDR infringement. If someone genuinely comes up with the same design entirely on their own, without ever seeing or referencing yours, you cannot sue them for UDR infringement, even if the designs are identical. The Ocular Sciences case confirmed this principle applies to UDR.
Okay, so primary infringement is making articles, or the means to make them, based on copying the design. What about secondary infringement, dealing in infringing goods?
Yes, Section 227 covers secondary infringement. This catches the usual downstream commercial activities with articles that are infringing copies, i.e. made through primary infringement. It includes importing them into the UK for commercial purposes, possessing them in the course of a business, or selling, letting for hire, or offering or exposing them for sale or hire in the course of a business.
And does the secondary infringer need to know they were dealing with infringing copies?
Yes. Similar to copyright secondary infringement, Section 227 requires that the defendant knew or had reason to believe that the articles in question were infringing copies of the design right. That knowledge element is key for secondary liability.
What about remedies if infringement is proven? Is it the same as copyright, injunctions, damages?
The available civil remedies, set out in Section 229, are broadly similar to those for copyright infringement. The court can grant injunctions to stop the infringement, award damages to compensate the owner for their loss, or order an account of profits, where the infringer pays over the profits they made from infringement.
But you mentioned some key differences from copyright remedies earlier.
Yes, two important ones. First, under UDR, there is no provision for seizure of infringing copies, unlike the self-help remedy sometimes available in copyright. Second, there are no criminal penalties for UDR infringement, whereas serious commercial copyright infringement can be a criminal offense. UDR is purely a civil matter.
And what about innocent infringement? Can someone be liable if they didn't know they were infringing?
Section 233 deals with this. If a defendant proves they were an innocent primary infringer, meaning they didn't know and had no reason to believe that UDR subsisted in the design they copied, then the owner is not entitled to damages against them, although they can still get an injunction or potentially an account of profits.
So innocence protects against damages for the maker. What about dealers, secondary infringers?
Innocence works slightly differently for secondary infringers. Remember, secondary infringement itself requires knowledge or reason to believe. But Section 233 adds that if a secondary infringer proves they were innocent at the time they acquired the infringing article, the damages awarded against them are limited to a reasonable royalty, basically, what they would have paid for a license.
Okay. And those licenses of right in the last 5 years affect remedies too.
Yes, if you bring an infringement action during that last 5-year period when licenses of right are available, the infringer can give an undertaking under sections 237, 239 to take a license of right. If they do, the remedies available against them are limited. For example, an injunction might not be granted.
Okay, now this seems really important based on the source material and what you've hinted at. The test for primary infringement under UDR is said to be crucially different from the copyright test for infringement. Can you explain that difference? This sounds like a key point for exams.
It's absolutely vital to grasp this distinction. Yes, it stems from the specific wording in Section 22062, which defines infringement as reproducing the design so as to produce articles exactly or substantially to that design. That phrase, substantially to that design, is interpreted differently from copyright's substantial part.
Okay, so copyright asks, did they copy a substantial part of the original work? But UDR asks, is the article they produce substantially to the original design? How does the court assess this substantially to that design test in practice?
The court undertakes a direct comparison. It compares the alleged infringing article made by the defendant directly with the claimant's original design, as embodied in the original design document or the article first made to the design. The court asks two questions. One, did copying take place? Was there derivation? And two, if yes, is the alleged infringing article made exactly or substantially to that specific design owned by the claimant? And this assessment of whether it's substantially to that design is an objective test. It's judged through the eyes of the person to whom the design is directed, according to the formulation by Mr. Justice Aldous, as he then was, in the key case C&H Engineering v. F. Klusnick.
The person to whom the design is directed, who is that? Is it the end consumer or someone in the trade? Is it the same as the informed user from Registered Designs?
It's generally thought to be someone more like the interested end consumer or user of the type of article in question, rather than a technical expert. Maybe slightly less sophisticated or knowledgeable than the informed user for Registered Designs, but someone familiar with the product type and its appearance.
And this is where the difference from the copyright test really comes in.
Yes, recent cases like Original Beauty Technology Co., Ltd. v. G4K, Fashion Limited, and Neptune Europe, Ltd. v. Volkissions, Ltd., explicitly state that the UDR infringement test, substantially to that design, is distinct from and requires a different comparison than the copyright infringement test, substantial part.
How is the comparison different?
The key difference highlighted in Original Beauty Technology is that for UDR infringement, when comparing the claimant's design and the defendant's article, the court must consider the differences as well as the similarities. You're not just looking to see if an important chunk of the original was copied, like in copyright substantial part test. Instead, you're making a more holistic assessment. Does the defendant's finished article, viewed overall, look substantially the same as the claimant's protected design? The differences might be enough to avoid infringement, even if some similarities exist due to copying.
Considering differences as well as similarities, that feels like it could be a harder test for the claimant to satisfy than the copyright test. You have to show the overall designs are substantially the same, not just that a key part was lifted.
It can be, yes.
Hmm.
It's a comparison of the totality of the designs embodied in the articles. Now, how do those features we discussed earlier, the excluded ones, like must fit, and the commonplace ones, affect this infringement comparison?
Good question. If a feature is excluded from protection, or if it's commonplace, do you ignore it when deciding if the defendant's article is substantially the same?
HHJ Hakon clarified this important point in Action Storage Systems, Ltd. v. GeForceEurope.com, Ltd. His approach was, excluded features under Section 213.3 Method Construction must fit, must match, surface decoration. These features, in which design right does not subsist, should be disregarded entirely when considering infringement under Section 226. The comparison for infringement is made only between the features in the claimant's design in which design right legally subsists. Commonplace features, which fail the SN2134 test but are part of a design that overall isn't commonplace. These features are included in the infringement assessment. If the design as a whole is considered not commonplace, perhaps because of a novel combination of commonplace features, then infringement is determined by comparing the defendant's article to the whole design as it subsists, including its commonplace elements. You don't ignore the commonplace bits when assessing substantiality if the overall design qualifies. This follows earlier reasoning from Aldous J. and C&H Engineering.
Okay, that's a very important distinction for the infringement test. Excluded features are ignored completely, Commonplace features, if part of an overall non-commonplace design, are still considered in the comparison.
Exactly. And just to reiterate, independent creation is always a complete defense. If the defendant can prove they didn't copy, it doesn't matter how similar their article is. Cases like Elbert Packaging Ltd v. Nampak Cartons and ProTech Covers Ltd v. Specialized Covers Ltd are examples where independent creation was successfully argued.
And finally, the IPA 2014 added some new standard defenses to UDR infringement.
Yes, it introduced defenses mirroring those for registered designs and patents, bringing UDR more into line. These cover things like acts done privately for non-commercial purposes, acts done for experimental purposes, teaching purposes, and use relating to equipment on foreign ships or aircraft, temporarily in the UK.
Right, so UDR provides shorter automatic protection for concrete shapes configurations that aren't excluded, method, fit, match, surface decoration, and are original, not copied A&D, not commonplace. Qualification is strict, based on ukiyoical links of designer-employer first marketer. Ownership follows qualification with the commission rule change. Effective exclusive term is shorter than copyright due to licenses of right. Infringement requires proving copying A&D that the resulting article is made substantially to the protected design, an objective test considering differences and similarities, ignoring excluded features but including commonplace ones. Okay, let's try and pull all these complex threads together now by walking through the sample question from the source materials. This is the one about Annie the potter, just to remind everyone. Annie is an Australian potter living in New York. She designs a unique teapot. Key features are a flower bud handle, a bird's head spout, a specific leaf pattern on the outside surface, and some special internal grooves she claims keep tea hotter. She exhibits the original teapot in a London museum. Later, a UK company, Josiah Puluric, gets a license and manufactures and sells these teapots in the UK. Sometime after that, a retailer, Okia Furniture Store, starts selling its own range. A cooking pot with similar internal grooves and a flower handle, a watering can with a bird's head spout, and a coffee mug with a leaf pattern very similar to Annie's. The question is, can Annie or Josiah Puluric take action against Okia?
This scenario is a perfect illustration of how these different areas of design protection, copyright, and UDR overlap and interact, and particularly how that pivotal Section 51 of the CDPA acts as a gatekeeper. The recommended approach from the source is to start by asking that crucial Section 51 question. Is Annie's original teapot, or any design document she made for it, a design for an article other than an artistic work? Because the answer dictates whether copyright or UDR is the primary route. You probably need to explore both possibilities.
Okay, let's take alternative A first. What if Annie's teapot is considered an artistic work in its own right? Maybe it's incredibly sculptural.
Right. If the teapot itself is legally deemed an artistic work, perhaps it qualifies as a work of artistic craftsmanship under Section 41C, or maybe even a sculpture under Section 41A. To decide this, you'd apply the test from cases like Hencher, Bondcrest, and especially Lucasfilm. You'd also consider the EU-derived originality standard from Kofmel and Waterrower. Did Annie exercise sufficient free creative choices in its shape and appearance, going beyond purely functional constraints?
Let's assume, for this alternative, that, yes, it does qualify as, say, a work of artistic craftsmanship. What then?
If the teapot is an artistic work, then Section 51 CDPA does not apply to prevent copyright protection for the teapot's shape. The exception in S.51 other than an artistic work is triggered.
So copyright protection is potentially available for the teapot shape itself.
Yes. You'd then quickly check the basic copyright subsistence requirements. Is it original? Yes, Annie created it. Is it fixed? Yes, in the physical teapot itself. Is the author a qualifying person for UK copyright? Annie is Australian, resident in NY. Australia and the USA are both members of the Berne Convention. So yes, Annie is a qualifying person for UK copyright purposes under Part 1 of the CDPA. Copyright subsists in the teapot as an artistic work.
And who owns that copyright?
Annie. As the creator, author of the artistic work, she's the first owner of the copyright under the standard rules in Part 1 of the CDPA. Josiah Lennox has a license.
So, under Alternative A, teapot artistic work, Annie owns the copyright, and Section 51 doesn't block her claim based on the teapot's shape. Can she sue Okia for infringement?
Yes, Annie could sue Okia for copyright infringement. The next step would be to assess if Okia has committed any of the restricted acts under Section 16 CDPA, most likely reproduction, Section 17, by making their pot, watering can, and mug, or perhaps issuing copies to the public, Section 18.
And she'd have to prove copying.
Yes, she'd need to show Okia actually copied her teapot design, derivation, and that the features they took, the grooves, handles, spout, maybe the leaf pattern, constitute a substantial part of her original artistic work. applying the Designers Guild qualitative test. If she can show that, she could potentially get remedies like an injunction and damages.
Okay, that's alternative A. Now for alternative B, what if Annie's teapot is not considered an artistic work in its own right? Perhaps it's very well designed functionally, but just doesn't reach the threshold for sculpture or artistic craftsmanship. It's just a nice manufactured teapot.
Right. In this scenario, the design for the teapot is caught squarely by Section 51(1) CDPA. It's a design for an article, the teapot, which is other than an artistic work. Therefore, making articles to that design, like Okea's cooking pot, watering can, and mug, would not be an infringement of any copyright Annie might have in her original design drawings or the model teapot.
So Annie's copyright claim against Okea based on the copying of the teapot shape is barred by Section 51.
Correct. Under this alternative, she or Josiah cannot use copyright to protect the 3D shape. They would have to rely entirely on unregistered design right, UDR, under Part 3 of the CDPA.
Okay, so if S.51 applies, we switch gears completely and analyze under UBR in Section 213. Where do we start?
You start by assessing if UDR subsists in Annie's teapot design, or specific features of it. First, does it meet the definition in Section 213.2? Is it the shape or configuration, internal or external, of the whole or part of an article? Yes, the teapot is an article, and features like the handle, spout, internal grooves are potential parts involving shape or configuration. We assume they are concrete, non-trivial parts post-IPA 2014.
Okay. Then the originality test from Section 213.4.
Yes. Is it original? First part. Was it copied by Annie? No, she designed it herself. Second part. Is it not commonplace in the relevant design field? Teapots, maybe broader kitchenware. At the time she created it. You'd apply the farmer build test here. Compare Annie's design objectively against prior designs by others in the field. Her inspiration from a Chinese museum is irrelevant to this test. Commonplace looks at what was already available from unconnected persons in qualifying countries. Dyson v. Qualtex confirmed prior art base. Let's assume for now that at least some features, like the specific flower bud handle or bird's head spout, are indeed not commonplace.
But we also have to apply the exclusions under Section 213.3 to each feature before testing for commonplace.
Crucially, yes. You mentally subtract the excluded bits first. Let's look at Annie's features. The internal grooves. Annie claims they keep tea hotter. Could these be excluded under Section 213.3 as features dictated by a method or principle of construction, or perhaps function? If that specific groove shape is the only way to achieve that claimed heat retention function, which seems unlikely but possible, then yes, they might be excluded. If it's just one way to do it, maybe not. The leaf pattern on the outside. This looks very likely to be surface decoration under Section 213.3c, and therefore excluded from UDR protection based on shape. Though remember, the pattern itself might get separate copyright protection as a 2D artistic work if Annie sues for that. The flower bread handle and bird's head spout. These are primarily features of shape. Are they caught by the must-fit exclusion? The handle needs to fit the hand, but that's usually not enough. Do they need to connect to another article? Not obviously. Are they caught by the must-match exclusion?
They are integral parts of the teapot. But is their specific shape dependent on the overall appearance of the teapot, such that the pot would look radically different without these specific shapes? Applying the Dyson test? Probably not. There could be many handle spout shapes. So these features are likely protectable under UDR, provided they are not commonplace.
Okay, so let's assume the handle and spout designs survive the exclusions and the commonplace test, so UDR could subsist in them. What about the qualification requirement? Annie herself isn't a qualifying person, Australian resident in NY.
Correct. Qualification cannot be based on Annie as the designer. We're not told she was employed, so that's why 220 likely doesn't apply.
So we move to Step 3, Section 220. Did the design qualify based on first marketing? Yes. Josiah Plex is a UK company, incorporated in a qualifying country, so Josiah is a qualifying person. Josiah Plex first marketed the teapots in the UK, a qualifying country. So yes, UDR does subsist, qualified through Josiah Plex first marketing activities.
And ownership, if qualification depends on first marketing.
Then under Section 215.4, Josiah Pleck, the company who first marketed the design in a qualifying country, is the first owner of the UDR. This is a crucial outcome. Annie does not own the UDR. Josiah Pleck does.
So only Josiah Pleck can sue Okea for UDR infringement.
Correct. Annie has no standing to sue for UDR infringement here. Josiah Pleck must bring the claim. Okay, so Josiah owns the UDR in, say, the teapot's handle and spout designs. Have Okea's products infringed Josiah's UDR under Section 226? What does Josiah need to show?
Josiah Pleck needs to show two things for primary infringement. One, that Okea copied their design, derived from Annie's teapot, presumably via Josiah's marketed product. And two, that Okea's articles,
the cooking pot with the flower handle, the watering can with the bird's head spout, are made exactly or substantially to that design, i.e. substantially to the protected handle design or the protected spout design from the original teapot.
And they apply that objective UDR infringement test.
Yes, the test from C&H Engineering.
Right.
With the person the design is directed to, maybe a home goods buyer, think Okia's articles embody a design substantially the same as Josiah's protected handle spout design. Remember, Josiah would need to show this considering differences as well as similarities between the original design features and Okia's versions, original beauty technology.
Does the fact that Okia has put the handle on a cooking pot and the spout on a watering can rather than a teapot matter for infringement?
No, that doesn't prevent infringement of the UDR in the design feature itself. As highlighted in Electronic Techniques, Anglia Ltd v. Critchley Components Ltd, applying a protected design, like the handle shape, to a different type of article is still reproduction of that design. So taking the protected bird's head spout design and putting it on a watering can could absolutely be UDR infringement of the spout design, provided it was copied and the resulting spout on the watering can is substantially to the original protected spout design.
Okay. What about the coffee mug with the leaf pattern?
Well, we decided the leaf pattern was likely excluded from UDR as surface decoration under S.213C, so Josiah probably couldn't sue for UDR infringement regarding the mug. However, Annie might have a separate claim for copyright infringement of the pattern itself as a 2D artistic work, assuming it's original, as surface decoration isn't excluded from copyright in the same way.
So for each of Okia's products, Josiah, not Annie, would need to identify the specific features copied from the teapot, check if UDR subsists in those features, surviving S.213 definition, S.213 exclusions, and S.213 commonplace test. Confirm Josiah owns the UDR, which they likely do via first marketing. Prove Okia copied. And prove Okia's article incorporates features made substantially to Josiah's protected design, looking at the whole comparison.
Precisely. You'd go through that analysis for the handle on the cooking pot and the spout on the watering can. You'd also mention potential remedies for Josiah, injunction, damage to count, and any applicable defenses for Okia, like arguing independent creation, or maybe that the features were actually commonplace or that their versions aren't substantially the same considering the differences. And you might mention the possibility of licenses of right if the UDR term happened to be in its last 5 years.
Wow, okay. That sample question really does force you to work through the entire analytical process, starting with that absolutely critical Section 51 gateway, potentially bouncing between copyright and UDR, applying all the detailed definitions and exclusions for UDR, double-checking the tricky qualification and ownership rules, which might not follow the designer, and finally applying the very specific UDR infringement test, which differs from copyright. It shows just how many steps and potential pitfalls there are.
It's a great illustration of why navigating design protection in the UK requires careful thought and why people describe it as complex. You need to follow the steps methodically.
So there we have it. We've taken a deep dive into the multi-layered, sometimes complex, and yeah, occasionally illogical world of protecting designs here in the UK. We've explored the potential role of copyright, the crucial limitations imposed by Section 51, and the alternative unique protection offered by the UK Unregistered Design Right, UDR.
It's definitely clear that understanding the specific nuances of each system is absolutely vital. Knowing when copyright might still apply, especially for artistic works, when Section 51 acts as a barrier and pushes you towards UDR, getting the UDR definition right under Section 213, shape configuration, part, article, not commonplace, avoiding exclusions, and appreciating the different infringement tests for each piece. These are fundamental pieces of the puzzle, particularly important for exams.
Absolutely. For anyone creating or dealing with designs, it seems it's rarely a simple case of is it protected or not. The answer really depends on the nature of the design, how it was created, who created it, and where it was first marketed, and whether it fits neatly into the specific, sometimes quite narrow legal criteria of these different overlapping systems.
That's right. Ultimately, the law tries to strike a balance, doesn't it? Between promoting and rewarding creative design effort on the one hand, and allowing fair competition, innovation, and access to necessary items like spare parts on the other. It's a delicate balance, and that's reflected in the intricate and sometimes confusing rules we've discussed today.
Something to ponder, perhaps. The next time you pick up a really well-designed object, just think about the journey its appearance might have taken through this legal landscape. Was it registered? Does it rely on UDR? Could it even claim copyright? Or was it perhaps left open for others to copy? Food for thought. Thank you for joining us on this deep dive. We hope this journey through the complexities of UK design law has been illuminating and helpful, particularly for those students preparing for exams. Remember those key cases? British Leyland, Cofamel, Water Rower, Farmer Build, C&H Engineering, Dyson v. Qualtex, and the key sections like S.4, plus N17, N.51, and especially S.213 for UDR.
This session was brought to you by Sinorbit Academy, Sri Lanka, using educational materials made available by the University of London. We wish everyone studying the very best of luck.